Hey everyone, my name is Adrian. I'm here with Nate from Nettleman Land Consultants. In this 5-part video series, we're going to talk about a deep dive basically into Certificate of Merit. Now, attorneys that live in states where that the Certificate of Merit is set up will probably know what we're talking about. But for those who don't, or for those who just kind of know a little bit about it, we'll do a little bit of an overview in history today. And then in the next upcoming videos, we'll kind of dive deeper and explain sort of the more nuances and the details throughout the country. We're also going to take a look at the consequences of not filing the Certificate of Merit when the law requires it. So lastly, we will invite you to contact Nettleman Land Consultants with any questions regarding the Certificates of Merit, particularly in the land boundary disputes. So without further ado, I would like to welcome Nate.
All right. Well, thank you, Adrian. And we appreciate everyone viewing. As Adrian stated, this is going to be an informative 5-part video series on the Certificate of Merit, or in some states, it's called the Affidavit of Merit, but it's the same thing. So in this first video, we're going to just look at the history of the Certificate of Merit, which I guess is more educational and informative for you attorneys out there who use it in your everyday litigation practice. Looking at, how did this requirement come to be? We'll take a look at that in this first video. And the next 2 videos after this will take a closer look at the 12 states in America that currently have the Certificate of Merit requirement. We'll take a look at, what particular statutes say about the Certificate of Merit, what needs to be in the Certificate of Merit, and probably most consequential for practicing attorneys, what are the consequences if you don't file the Certificate of Merit? We'll take a look at what the 12 state statutes say about that.
So just to clarify, so like the attorneys will understand kind of like the end of the video series, they'll understand what kind of cases this would apply to if they're in one of the 12 states, and then kind of the details of it, along with sort of what will happen if I don't follow the sort of the letter of the law there.
Right, exactly. And that's a great segue into, our discussion about the history, is that the Certificate of Merit only applies in certain types of civil litigation cases. It applies in what's known as professional malpractice or professional negligence cases. So these types of cases would include medical malpractice, legal malpractice in some states, those professions that generally require a license.
Yeah.
Doctors, lawyers, surveyors, architects, engineers. These are the types of cases where Certificate of Merit would be required. You don't see a Certificate of Merit requirement in a simple breach of contract case, for example. It's very specific to professional malpractice or professional negligence litigation.
So it qualifies the level of involvement, or what the process would be in terms of the expert in this case. Like medical malpractice obviously would have a description. It would also keep sort of smaller cases from coming up against them, so it sort of protects the experts to a point, but also it's an extra step in terms of structure, right? Is that what I'm hearing?
It is. It's a preliminary. It's a preliminary requirement,
okay.
Which, the original purpose of the Certificate of Merit, going back to, the 1960s and 70s, when the Certificate of Merit requirement first sort of, entered the courtroom, was to prevent what's known as frivolous lawsuits.
Yeah.
People that, believed that they were harmed by a certain professional were running into court and suing them, mostly medical malpractice cases is really where the requirement came from.
Yeah.
Because in the 60s and 70s, there, was a slew of medical malpractice, doctors, insurance companies, lawyers, elected officials started to see this, and kind of wanted to put a preliminary safeguard in place to prevent litigants from, in my words, wasting the court's time with a frivolous claim. So the Certificate of Merit basically is a lawyer's or a party's requirement to consult with an expert in that particular area of expertise, whether it be the medical field, whether it be in the law, whether it be a surveyor, another professional engineer or architect, someone who is an expert and has a requisite set of knowledge in that particular field,
Right.
that can work with the attorney or the party that is looking to sue a professional. And that expert can take a look at, the facts of the case, can take a look at what claims that lawyer or litigant is looking to bring to court. And based on that expert's knowledge, expertise, experience, that expert can say to the expert, that expert can say to that lawyer or to that party, yeah, you have a case here.
Yeah.
There's something substantive here.
Yeah.
And can put that into a formal document, which is
right. So you can either validate it, or if it's not a legitimate one, keep it from sort of wasting everyone's time and getting into the system in terms of going to. Okay, that makes sense.
Right. So it's basically a lawyer or litigant's requirement to consult with an expert prior to even filing suit.
Okay.
Which sometimes is seen as a barrier to litigation, but those on the other side would argue that it is it's a preventative tactic to avoid frivolous litigation.
It's like a step of vetting by an expert that obviously would be the first step in these, especially in these 12 states you're referencing, and keeping the flood of maybe smaller unnecessary civil suits out of the court.
Exactly.
Yeah.
So as I mentioned, this requirement was pretty much born out of waves of tort reform, mainly in the 70s and 80s here in the United States. Medical professionals, insurers, legislators were concerned about the increasing number of frivolous or meritless litigations. So Pennsylvania, interestingly, this was very interesting in my research on the Certificate of Merit. Pennsylvania, where I was born, and California were the first two states to really enact legislation and take seriously the Certificate of Merit requirement. Pennsylvania did so around 1976.
Okay, so towards the beginning, kind of like led the way in terms of the creation of that, in terms of kind of being a trailblazer for individual states.
Yeah, Pennsylvania and California. Actually, California's Medical Injury Compensation Reform Act, MICRA, as it's sometimes known, was put into place in 1975, and that focused mainly on caps to damages, to the amount of damages, but it also led to broader tort reform debates, which again set sort of the stage for the procedural reforms that have resulted in Certificate of Merit requirements in 11 other states.
That makes sense. It's obviously a process where you've got the refinements you make along the way. Then so you're solving the problem, but you're kind of learning what kind of the reform you need to be doing like throughout the years since then. Nice.
Right. So after that, there was really a spread nationwide into other states in the early 80s, mid 80s, and then into the 90s of other states enacting laws that required plaintiffs to file a Certificate of Merit, either prior to filing suit and or at the time of filing the initial complaint or petition. There's been some judicial scrutiny of the Certificate of Merit, especially in those early days in the 70s, 80s, and 90s. But for the most part, most higher courts have upheld the constitutionality and other substantive requirements of these Certificate of Merit statutes. Again, as I mentioned previously, some parties would argue that it creates an unnecessary burden at the beginning. Basically, my reading of all of the judicial opinions on this is that it meets its purpose in terms of weeding out frivolous and meritless claims.
That makes sense. And the refinements, I'm sure, is if it feels like it's going one way or the other, if it feels like it's too restrictive or in keeping people from bringing legitimate lawsuits, but also at the same time, I'm guessing not making it so that it's too easy to go to court, like not just a check mark of the certificate of merit, but actually a kind of a full vetting in terms of for each, and obviously each state does it differently, but that sounds like there's, they find that balance over the years. Is that kind of how it started in the 70s and kind of evolved to today is just seeing what worked for other states, I'm guessing, and then adapting it accordingly.
Right, exactly. And, as I mentioned, and we'll wrap up the history section here, because we'll get more in depth into state requirements in the next two videos. But yeah, I mean, starting in the 70s and 80s with the whole medical malpractice, movement to cap damages and limit the amount of relief that someone could get if they claimed medical malpractice, expanding the requirement to other professions. It now includes, as I mentioned, architects, surveyors, engineers, in some cases lawyers. So yeah, it's been evolving.
Yeah.
And it has evolved from the 70s into where it is now. But the original purpose and the original intent has pretty much remained the same and is uniform across the 12 states that currently have it in their statutes.
That makes sense. And I think it's really interesting historically, just to hear about the beginnings of it in one industry and sort of deciding which industries it would make sense for. So as you mentioned, kind of in our next video, we'll do a little dive into the different states and see the requirements and how it applies to sort of the everyday litigation. Great. Well, thanks a lot for your time and for the history lesson.
All right. We'll see you in the next one.